Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidyarati. Today in this video, let us learn about harmonious construction. Harmonious construction. Before beginning about this topic, let me give you a day-to-day example. When there is a conflict between two brothers in a family, the parents will intervene to sort out their problem harmoniously, making them happy and giving them a solution. In the similar way, the rule of harmonious construction is applied by the courts if there is any such situation arising in the statutory provisions. Earlier, we have covered the literal or the grammatical rule, golden rule, mischief rule, ejusdem generis, and the nocitur associis. Now, let us learn about the rule of harmonious construction. Coming to the meaning, when two or more provisions of the same statutes are conflicting with each other, the court will try to construe the provisions in such a manner to give effect to both by harmonizing them with each other. The court may do so by regarding two or more apparently conflicting provisions as dealing with separate situations or by holding that one provision merely provides for an exception of the general rule contained in the other. The basis of the principle of the harmonious construction probably is that the legislature might have not intended to contradict itself. This principle has been applied in a very large number of cases dealing with the interpretation of the Constitution. So, also in the case of apparent conflict between the provision of the same act, the courts may harmonize them to give priority to one over the other. The court will not declare any conflict sections which are not valid. So, overall, the provisions are there. The real intention of the legislature in providing such provisions to have no conflicts among the statutes. Coming to the judicial approach, in the case of Minerva Mills versus Union of India, there was a conflict arising who is the supreme, either the fundamental rights or the directive principles of the state policy. So the Supreme Court gave a statement that the Constitution of India was built on the bedrocks of both the fundamental rights and the directive principles of the state policy. These are not conflicting with each other, but they are complementary to each other. In another case of MSM Sharma versus Krishna Sinha, here MSM Sharma, the petitioner, he was a journalist and editor of an English newspaper Searchlight, and also he was an MLA. And here Krishna Sinha, the respondent, he was the Chief Minister of Bihar. And what happened in this case is MSM Sharma, he was talking in the assembly, and what he did is, whatever he spoke in this assembly, he directly wrote the same statements in the newspaper without any editing. Actually, what happened is the few words which are not liked by the speaker are expunged. But these expunged statements are also written in the newspaper, which was taken into consideration. So he was not following the rules of the speaker, and those words which are expunged are being written in the newspaper, and in this way the case was filed. Here the petitioner MSM Sharma says, I have the right to speak, and using the article, I have the fundamental right of Article 19(1) Clause A, the right to speak. This was actually infringed because the speaker has said that I have expunged certain statements and you wrote those statements. So this was the case in which the petitioner has infringed his rights of fundamental rights of speech. So here the question is whether the Constitution of India under Article 194 Clause 3 empowers a state legislative assembly to restrict any publication of a proceeding that has been witnessed by its members, or prohibit the publication of parts that has been directed to be expunged. So because the statements have been expunged by the speaker, those statements should not have been published in the newspaper. In another question raised was whether the said privilege under Article 194 Clause 3 have an upper hand over the Article 19 Clause 1 Clause A, that is right to speech, which grants a fundamental right of free speech and expression to every citizen of India. So these two questions arose, which is on upper hand, either the Article 194 Clause 3 or the Article Fundamental Right of Article 19 Clause 1 Clause A. So the Supreme Court, it said that the conflict of arising of the articles in between the Articles 19 1 Clause A and Article 194 Clause 3 both stand out to have an equivalent importance, and no one is superior over the other. Here, the case has to be considered in a harmonious manner. That harmonious principle of construction should be applied. With Article 19 Clause A stands as a general and Article 194 Clause 3 stands as special. Hence, the court deducted a conclusion that the notice by the assembly stands valid and the petition stands dismissed. So, here a little authority, a little supremacy is given to Article 194 Clause 3 as the words are to be expunged before publication. That statement need to be considered, and here there is no infringement of the rights of right to speak. The fundamental rights is not infringed, but there is a higher side of upper hand of Article 194 Clause 3. In another case of D. Sanjeevaya versus Election Tribunal, the petitioner Sanjeevaya challenged that another person has been elected in the place of him. During the pendency of his petition, the appellant, he got elected for the Rajya Sabha, and so he resigned from the assembly. So he filed a writ petition to the High Court and said that a by-election should be conducted by the Election Tribunal because a seat is vacated by the appellant. So under Section 150 of the People Representative Act 1951, by-election should be conducted for the seat which is vacated by the appellant. So the High Court, what it did, already the seat is vacated and you wrote a petition regarding him. So we will dismiss this petition. So the Supreme Court also was in agreement with the High Court, because the decision which was taken by the High Court is in consonance with the Section 150 could not be interpreted in solely, because the court has to relate to other provisions of the acts of Sections 84 and 98C along with Section 150. Considering Section 150 harmoniously with these two sections should take into conclusion that Section 150 did not intended the election petition should stand dismissed with the resignation of the member against whom the petition has brought. So the conclusion is that we cannot consider the single Section 150 of the People's Representation Act, that one has already vacated the seat and now the by-election can take place to fill the seat, but the person who has elected for Rajya Sabha, he resigned it before the petition, before the conclusion has came. So these two sections along with Section 150 and Sections 84 and 98C has to be harmoniously interpreted to make out a conclusion whether the petition has to be taken into consideration or not. In another case of Krishna versus Bino, in this case, there was a conflict arising between Sections 33 Clause 2 and 123 Clause 8 of Representation of People's Act 1951. Here, no one will go on upper hand and no one will go on the lower hand. Section 33 Clause 2 empowers the government servant to nominate or second a candidate who is participating for election. And another section is 123 Clause 8 says that the government servant should not assist the candidate in election but except for casting a vote. So here the government servant was having two authorities, to nominate or second a candidate seeking the election and also to cast a vote without assisting him in the elections for any kind of malpractice. So harmoniously we need to construct the conclusion that the two sections go hand in hand harmoniously to make it a smooth manner. So the conclusion here is the rule of harmonious construction avoids the collision between the provisions of the same statute. It is applied with the object to save the real intention of the legislature in incorporating such provisions which appear to be conflicting. So the judiciary makes them complementary by this construction. So the real intention of the legislation is not to make conflicts but to go hand in hand with the provisions and try to make out a good conclusion to give good justice to the people who are seeking for the justice. As such, we have come to the end of the video. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe my channel for many more interesting topics. Thank you.